All right. So good morning, good afternoon, good time of day, depending on your time zone. Welcome to our seminar. I am Marco Rocca. I am the principal investigator of the European Birds of Passage project, an empirical legal theory of temporary labor migration in Europe. We are based in Strasbourg, and we deal with social rights of temporary labor migrants in the European Union and to the European Union. So today's seminar is about labor migration and the legal boundaries of exploitation. And we are very happy to have Judy Fudge, Mireia Llobera Villa, and our very own Catarina Lopez Codru as our speakers for today. We are all the more happy that Judy and Mireia are physically with us in Strasbourg. And the occasion was a very fortunate one because yesterday our PhD student Audrey Deverson defended her PhD thesis. Mireia and Judy were in the jury. The PhD thesis was titled Access to Social Rights for Temporary Labor Migrant Women in the European Union, an intersectional perspective on seasonal and posted workers in France and Spain. And so if the title entices you, the manuscript of the thesis will be open access. So keep an eye on our website and it will be linked there. So without further ado, because you will hear me again at the end of the seminar to close it, I will give the floor to our first speaker, Professor Judy Fudge. Judy, you can switch on your microphone and you have the floor.
Hi, Marco. Would you put on the first slide? Thank you very much for the invitation to be here. And it really was a delight. It was an excellent thesis. So congratulations to Audrey. And I know Katerina will be defending her thesis later this year, and I expect it'll be just as brilliant. So it's a real pleasure to be here. The title of my paper is on this slide, and it's a very condensed version of the fourth chapter of a book I've written on constructing modern slavery. Slide 2, please. The most concentrated site of multiscalar governance, the European Union, has led the way in adopting region-wide binding legal norms to address human trafficking. Initially, the European Union's governing institutions approached human trafficking as a problem of organized crime and illegal immigration, focusing almost exclusively on sexual exploitation and prostitution. By 2012, however, labor trafficking was firmly on the agenda. EU governing institutions embraced a multifaceted approach based on human rights and systematically embedded in multiple policy instruments in policy areas ranging from security to migration, justice, equality, anti-discrimination, fundamental rights, and employment. Like its international counterparts, EU institutions also adopted highly gendered governance strategies for dealing with different kinds of exploitation in human trafficking, treating sexual and labor exploitation very, very differently. At the heart of the European Union's anti-trafficking strategy is an emphasis on cross-border movement, because that is what gives the European Union legislative authority over human trafficking. The EU's evolving membership and competencies have shaped its approach to human trafficking. In the wake of the breakup of the Soviet Union, the European Union intensified its twin projects of transnational governance and market expansion. Since 1990, the EU has gone through 3 episodes of significant constitutional change that have altered the scalar and governance dimensions of its competence. The first 2 episodes, the Maastricht and Amsterdam treaties, which occurred in the 1990s, triggered a project of criminal law harmonization. In contrast, the third constitutional moment, the Lisbon Treaty, which came into effect in 2009, supported a counter-movement boosted by the Council of Europe's Human Trafficking Convention to protect the rights of victims of trafficking. The dramatic expansion of the EU to include former socialist countries led to increased concerns in 2012 that migrant workers from recent accession states were subject to exploitation, and greater attention to the problem of labor trafficking followed. Slide 3, please. The first stage, the 1990s. The impending Soviet collapse revived Europe's long anxiety about sex trafficking, reacting white slavery narratives of white European women being exported to the colonies for prostitution, and fears of a Natasha trade from east to west. In 1989, the European Parliament urged ratification of the 1949 United Nations Convention on the Suppression of the Traffic in Persons and Exploitation of Prostitution of Others, treating both prostitution and coercive exploitation as crimes. The European Women's Lobby framed trafficking as a woman's right and violence against women issue, not as a morality issue, nor as a livelihood issue under constrained choices. Thus, it advocated the abolition of prostitution by criminalizing the demand for sexual services. This framing influenced European Union discourse, which by the mid-1990s regarded human trafficking only as sexual exploitation and illegal migration, best addressed via criminal law and border securitization, while recognizing limited EU competence in these areas. The Schengen regime, which abolished member state borders within the European Union in 1995, and the Maastricht Treaty, which came into effect in 1993, sharpened focus on border control and policy and judicial cooperation. But immigration and criminal matters remained primarily within member state jurisdiction, with the European Union playing a secondary transnational role. Slide 4, please. The 1997 Amsterdam Treaty opened room for common European Union policies on criminal justice, immigration, and social policy, but exposed divisions over harmonizing criminal law and human trafficking, especially regarding framing prostitution as work or as violence against women. This was because the definition of human trafficking in the United Nations 2000 protocol, which was ambiguous about whether prostitution per se or whether prostitution plus coercion was required to establish exploitation for the purpose of human trafficking. This ambiguity tied the EU's approach to human trafficking to member state criminal laws and policies around prostitution. Before the Amsterdam Treaty took full effect in 1999, EU countries revised prostitution laws across a spectrum. So in 1999, the laws in the EU around prostitution ranged from legalization, regulation, Austria, Spain, Luxembourg, the Netherlands, Germany, to toleration, not fully legal, but not illegal, Greece, France as it then was, Portugal, to full criminalization, Ireland, where both the selling and purchasing of sex was illegal, to the criminalization of the purchase of sexual services, Sweden and Finland. The Swedish model became the model that the EU wanted to adopt, and France has since followed. The dispute over how to regulate prostitution reflected broader fears about crime and internal movement controls amid EU enlargement, with migrant sex workers symbolizing these anxieties. Slide 5, please. The second stage, the framework decision on human trafficking and the temporary residence directive. In 2002, the EU adopted the framework decision on human trafficking under the treaty provisions on police and judicial cooperation in criminal matters. The framework decision was essentially a criminal law measure that outlined the elements of the crime of human trafficking and specified minimum criminal law penalties. It largely followed the definition of human trafficking in the United Nations Protocol, which left the relationship between prostitution and human trafficking to member states' discretion. However, the protections it offered to trafficking victims were even weaker than the United Nations protocol's optional provisions. Thus, the European Union promised to introduce an instrument more specifically regarding victims' rights. Due to concerns that binding protections would invite opportunistic abuse of residence permits by irregular migrants, EU states were very reluctant to commit to rights for trafficking victims who were non-nationals. After 2 years of negotiations, the Council adopted to the 2004 Residence Permit Directive under treaty powers on illegal immigration and residence. There is nothing about human rights in any of these. This directive seeks to strengthen action against trafficking and illegal migration by granting temporary residence permits and encouraging third country nationals to cooperate with law enforcement. It does not require member states to identify victims. However, if identified, they receive an unspecified reflection period during which expulsion is suspended, and they must be provided with adequate standard of living and access to emergency medical treatment. If victims do not cooperate, they may be deported. The 2002 Framework Decision and the Residence Permit Directive reinforce national sovereignty by giving member states a great deal of discretion over how to define human trafficking and the rights granted to victims, while at the same time framing human trafficking as a threat both to the EU's and to member states' security, a threat that required stronger borders against illegal migration and greater penalties against transnational crime. The European Union's anti-trafficking initiatives focused on sexual exploitation and prostitution. Migrant prostitution came to be seen as an inherent evil to be combated domestically and internationally. Migrants who were not EU nationals were targeted because the European Court of Justice ruled that EU nationals have the right to work as prostitutes in member states where the activity is not illegal. The Residence Permit Directive provided a humanitarian rationale for deporting migrant workers, regardless of member states' specific stance on prostitution, since they could easily be redefined as victims of trafficking and repatriated to their country of origin. Sex trafficking discourses operated as key elements in the construction of stronger borders in the European Union. Slide 6, please. The turn to protecting the rights of victims of trafficking. The Council of Europe, the leading pan-European human rights organization, played a critical role in shaping the EU's governance of human trafficking. In May 2005, the Council adopted the Convention on Action Against Trafficking in Human Beings, which supplemented both the United Nations Protocol and the EU Framework Decision by bringing a human rights perspective and its focus on victim protection. The Convention requires member states ratifying it to establish a mechanism for identifying victims. Ratifying states must provide full medical and other assistance and access to the labor market to victims with lawful immigration status. The Convention also detaches the obligation to protect victims from the victim's willingness to cooperate in the prosecution process. However, member states of the Council of Europe were unwilling to accept key victim protections on the ground that these protections would be exploited by undeserving victims. The Convention does not provide procedural guarantees for challenging a negative determination of an individual's status as a victim, nor does it prohibit states from prosecuting trafficking victims for other criminal offenses, such as illegal immigration or prostitution, that are linked to their status as victims of trafficking. In fact, none of the rights provided to victims in the European Council Convention are justiciable and as such cannot be enforced by victims via legal actions. Bolstered by the Council of Europe Convention, the European Commission began to steer other EU legislative institutions towards a more victim-oriented human rights approach to human trafficking. This was part of its general concern to strengthen the social dimension of the EU to compensate for its market expansion to formerly communist member states. Slide 7, please. The 2011 Human Trafficking Directive. In anticipation of the Treaty of Lisbon coming into effect, the Commission sought to institutionalize a hybrid anti-crime enforcement and victims-first approach to human rights in the context of human trafficking within the European Union. The 2011 Human Trafficking Directive combined increased coercive powers to tackle human trafficking with greater protections for victims along the lines of the Council of Europe Convention. It widened the substantive criminal law definition of trafficking, increased the penalties for human trafficking, added the crime of aggravated trafficking, expanded member state jurisdiction over human trafficking extraterritorial to include all acts committed by each member state's nationals anywhere in the world, and added a new provision on the seizure and confiscation of assets. It was a strongly coercive mechanism. Though the 2011 directive also integrated protection of victims' rights into its carceral approach. It requires member states to establish national referral mechanisms to identify victims, and all identified victims are entitled to reside in the country during a reflection period during which they can access a suite of social rights. However, it does not offer trafficked persons from states outside the EU greater protection from deportation than that provided in the 2002 framework decision. But even these small advances were resisted by member states. The European Commission repeatedly expressed its unhappiness with their transposition of the directive when it came to victim protection. Addressing labor trafficking in the European Union. With the release of its 2012-2016 human trafficking strategy, the EU sought to move beyond its almost exclusive focus on a carceral approach to human trafficking to develop a multidisciplinary, coherent policy. It broadened its concern beyond sex trafficking to give greater attention to labor exploitation, vowing to involve a more diverse group of actors, including labor inspectors, trade unions, employers' organizations, temporary and recruitment agencies, and policymaking. The European Union's attention to labor trafficking was a response to both the labor market turmoil caused by the 2008 fiscal crisis and a greatly enlarged European labor market composed of member states with different labor market institutions and outcomes, stressing the need for labor legislation to regulate migrant workers in the EU to prevent human trafficking. The 2012-2016 anti-trafficking strategy called for measures to address contractors, subcontractors, and recruitment agencies in high-risk sectors such as agriculture. There were, however, two big impediments to developing a coordinated strategy to addressing labor trafficking in the EU. The absence of a common understanding or definition of trafficking for labor exploitation in Europe, and member state competence over most aspects of labor regulation. Labor trafficking was neither recognized nor addressed by policy or practice in most European states, which helps to explain why the numbers of individuals identified as victims of labor trafficking in Europe was 1/4 that of the numbers of victims of sex trafficking in 2010. Two non-legislative and advisory EU institutions, the EU Fundamental Rights Agency and the European Foundation for Improvement of Living and Working Conditions, Eurofound, took up these matters. Both of these agencies focused on the exploitation of migrant workers as a form of human trafficking. the Fundamental Rights Agency embraced a human rights approach and proposed a new definition of labor exploitation that does not require coercion, that was based on the sanctions directive. Eurofound adopted a labor approach to the problem of labor trafficking and advocated the regulation of labor market intermediaries through licensing, certifications, and inspections, and the involvement of the social partners. However, because most aspects of labor market regulation fell outside the EU's jurisdiction, all the Commission could do was pass on policy recommendations to member states. Since most trafficking victims identified in the EU come from other EU countries, the Commission regarded regulating labor markets within EU member states as extremely important for combating labor trafficking. In 2019, the European Labour Authority, charged with ensuring that EU rules on labor mobility and social security coordination are enforced fairly and effectively, was created. While other EU and Council of Europe institutions were recommending labor law mechanisms for tackling human trafficking, the Commission concentrated on how member states had transposed the provisions in the 2011 Anti-Trafficking Directive having to do with criminalizing and discouraging demand. Criminalizing the use of services performed by a victim of trafficking is tied up with the regulation of prostitution. In 2014, the European Parliament reverted to its historical position of equating prostitution with sexual exploitation when it adopted a non-binding resolution that would criminalize the purchase of sexual services as a way of combating human trafficking. That year, the Parliamentary Assembly of the Council of Europe adopted a similar motion. Slide 8, please. The 2024 Human Trafficking Directive. In its 2021-25 anti-trafficking strategy, the Commission questioned whether the decade-old anti-trafficking directive was fit for purpose. After much study, in 2024, the EU adopted a new directive on human trafficking, which member states must impose this year. The 2024 directive reinforces the EU's approach to human trafficking of prioritizing the criminal law while protecting the rights of victims. It further expands the definition of human trafficking to include forced marriage, illegal adoption, and surrogacy, and requires member states to make it a criminal offense if a person who uses the services provided by a trafficking victim knows that the person is a victim of trafficking. Member states must also establish national anti-trafficking coordinators and formal referral mechanisms to promote the prompt identification of victims and the delivery of assistance. The possibilities of non-prosecution and non-application of penalties to victims of trafficking are expanded for administrative offenses related to prostitution, begging, loitering, or undeclared work. Slide 9. To conclude, the transnational and criminal nature of human trafficking is the legal basis for the EU's jurisdiction over anti-trafficking legislation. The Council of Europe's Convention and Human Rights Organization drove the European Union's turn towards protecting the rights of victims of trafficking. Human rights were incorporated within, but as subsumed under a governance strategy designed to harden the EU's and member states' borders to exclude undesirable outsiders. The borders demarcating the inside and outside of the EU have created a complex division of jurisdiction over different legal categories of mobile workers, such as free-moving EU citizens, third country nationals, posted workers, seasonal workers, illegal migrants, and victims of trafficking, with varied rights and entitlements and obligations for each category. Instead of operating as barriers, the borders operate as filters that sort desirable migrants from unacceptable ones. Victims of trafficking, especially those who are subject to sexual exploitation, epitomize unfreedom, and thus they are the antithesis of what the EU, with its embrace of free movement, is about. Combating sexual exploitation has been at the heart of the EU's anti-trafficking legislative initiatives, which has led to their entanglement with the controversial question about how to regulate sex work. EU legislative institutions have been much slower to address labor trafficking, which is considered a smaller, although growing problem. Different governance strategies are used to address sexual and labor exploitation. Abolishing prostitution is the goal of the former, whereas regulating, not abolishing migrant work, is the preferred technique for the latter. But even though the EU's anti-trafficking governance strategies construct the broad categories of hierarchically organized mobile workers, the bulk of the work of sorting mobile people into different legal categories still is performed by member states. Thank you very much. Thank you.
Thank you, Judy. I will be starting the next presentation. In the meantime, I will also give the floor to Mireia. Let me find your presentation, Mireia. So this is Judy's, and this is Mireia. Up.
Go back.
Yeah.
With these two. Okay. I think easy. All right. Good morning. Firstly, I would like to thank Dr. Marco Rocca and the University of Strasbourg for inviting me to participate in this insightful seminar. I also want to congratulate Ms. Deverson for her exceptional thesis, which is an insightful piece of work from which I have learned a lot. I was especially enriched by its treatment of intersectional discrimination, a topic I will also highlight in my presentation today. I will start with an introduction to the phenomenon of undeclared work and its consequences, and a description of valuable policies. I have actually chosen some examples from the National Plan to Tackle Illegal Work in France, and I will then move on to discuss the central topic of my presentation related to undeclared work on digital domestic service platforms in Spain. My research was conducted in the context of the European platform against undeclared work. And the first thing I witnessed was that undeclared work constitutes a system of exploitation of human need aimed at generating profits at the expense of dignity and the denial of fundamental rights. According to the most recent research, almost half of the global workforce is employed in the informal economy, and the significant presence of the informal economy is not only a challenge for labor rights, but also for social protection and the rule of law. The consequences of this phenomenon are detrimental to public revenues, which affects the ability of governments to implement public policies. Furthermore, this phenomenon affects the soundness of institutions and fair competition in national and international markets. According to the International Labour Organization, the main cause of entry into informal employment is not an individual choice, but rather a lack of opportunities in the formal sector and the absence of alternatives. Alternatives as, for example, a system to promote declared employment in the personal and home services sector, like the service vouchers in France. I am especially referring to le chèque emploi service universel. I have had the privilege to deliver a report to the European Labour Authority on the national plan to tackle illegal work in France. And certain characteristics of the plan were identified as particularly good practices. As, for example, its diversity policy in terms of gender, ethnic origin, age, and other parameters, which allows for a deeper and more diverse understanding of undeclared work. For that purpose, Inspectorate in France and also in Belgium hire citizens from third countries, including people with Moroccan, Turkish, or Romanian background to support the inspectorate activities. Secondly, the introduction of penalties based on social damage is another point to note, altogether with the existing incentives to encourage the transition to the declared economy. Thirdly, it's worth noting the creation of blacklists. I am referring to the web publication of a blacklist of companies convicted of criminal offenses related to illegal work. These companies are also excluded from public procurement, thus increasing the reputational and economic cost of illegal behavior. And last but not least, among many other measures, it's important to highlight the fact that an important part of the inspection work, possibly the most detailed I have found in any plan, is devoted to detecting illegal posting of workers, as well as to expanding the powers of agricultural control agents. In contrast, in Spain, for example, exploitation related to migration is well known, but the different challenges that temporary migration poses to labor systems are not. In this context, the case for personal and home care work, traditionally referred as domestic work, is particularly pertinent. Although undeclared work affects different sectors in all national economies, it tends to be concentrated in specific areas. Therefore, a sectoral approach can be more effective than a general one. This is the case for domestic work specifically. In this sector, this sector has the highest rates of undeclared work, and around 50 million out of 77 million in this sector worldwide are in informal employment. Sorry, I was reading the numbers. And worth noting, especially among women, and in particular among migrant women. Many countries are currently facing a crisis in the care sector caused by the aging population and the growing participation of women in the labor market. This situation has led families to increasingly rely on these workers to take care of their homes, children, and the elderly. So demand for workers in this sector is high, and however, barriers to obtaining regular residence make it difficult for migrant women to declare their jobs. In particular, Spain has one of the highest rates of undeclared work in this sector among industrialized countries. And migrant women represent 43% of the sector's workforce. The inviolability of private homes, guaranteed by the Spanish Constitution, requires the adaptation of investigation methods. As inspectors cannot access the workplaces and cannot check by themselves the conditions of these workers. For this reason, the labor inspection efforts have been directed towards digital platforms offering domestic services. However, their activities only achieve their objectives insofar as they get to hard-to-reach groups. These workers are less likely to be inspected and are often more vulnerable to poor working conditions, especially migrants, due to the difficulties they face in reporting their situation, given the risk of deportation. Therefore, investigation of digital intermediaries focuses on detecting undeclared or undeclared social security contributions, under-declared wages or working hours, non-declaration of employer status, and bogus employment contracts. These investigations have shown that digital intermediaries contact clients and organize the provision of services. They set the prices for the services to customers. They set the wages of the domestic workers. They are responsible for the clients, for the service quality. However, workers are not declared as employees, despite providing services on behalf of the company. In addition, Spain has sought to sign bilateral agreements to ensure adequate coverage of migrant domestic workers, allowing the portability of contribution periods and also of acquired benefits. For example, the agreements signed with the US and Morocco explicitly include workers in the domestic sector. Certainly, the formalization of the domestic services sector addresses the historical devaluation of predominantly female occupation, as 96% of those employed in this sector are women, and also contributes to the reduction of gender stereotypes and the wage gap. In fact, if employers complied with minimum wage levels for workers in the domestic sector, it is estimated that wage inequality could be reduced by up to 9% in Spain. Domestic workers' undeclared status is also linked, is very often linked to the unaffordability of these services in countries where little public financial support is given. There is also a link between domestic workers' working conditions and the quality of the services. It's for this reason that the French system of service vouchers is particularly noteworthy, as successive French governments have subsidized the cost of hiring workers in this sector. On another note, women in domestic service find themselves at a particularly dangerous intersection. In their case, the intersection of gender, race, and class defines the specific social disadvantage they face. This requires, as Andrew has well developed in her thesis, an intersectional approach that enables to move beyond the gender mainstreaming paradigm, as well as to move beyond the problematic lists of discrimination that result in a mere arithmetic sum. 12 European Union countries, recognize multiple discrimination, but only 2 of these, which are Belgium and Spain, have specific legal provisions on intersectional discrimination. And the first EU act that recognizes intersectional discrimination was the Pay Transparency Directive. As a result, the Spanish Labor Inspectorate is assessing intersectional discrimination using a hypothetical comparator. And what is a hypothetical comparator? The hypothetical comparator was introduced by the EU Pay Transparency Directive and allows a worker to establish a presumption of pay discrimination without identifying a real colleague in a comparable situation. Instead, this comparator is grounded in objective criteria, such as job classification, required skills, responsibilities, working conditions, and may also be supported by statistical evidence. The mechanism addresses the structural limitation of the traditional comparator test, particularly in segregated workplaces where no suitable real comparator exists. Let's put an example. Let's put a practical example involving gender, ethnicity, and migration status. Imagine Amina, a Moroccan woman with a resident permit, employed as a cleaner, and in her company, all cleaners are migrant women, no men perform cleaning work, and the only male employees work in different job categories. The problem under the traditional comparator text is that Amina cannot identify a male comparator in the same job. Therefore, comparing her to men in different roles is rejected by the courts as non-comparable. In contrast, using a hypothetical comparator, Amina may construct a comparator such as a male, non-migrant worker, performing work of equal value based on job evaluation, required skills, responsibilities, and working conditions would receive a higher pay. Therefore, to finalize, I believe it is essential to transition to a new intersectional context in which the diversity paradigm complements the equal opportunities paradigm. Ultimately, combating undeclared work, especially in sectors dominated by migrant women, requires a combination of robust legal tools, innovative inspection strategies, and intersectoral discrimination techniques. As if we aim for a labor market that is fair, transparent, and dignified, this requires an integral approach, which is not an option, but rather it is indispensable. Thank you so much.
So I will put on the next presentation and then leave the place to Katarina. So let me find your presentation up. This one. There you go.
Okay, so thank you very much and good morning, everyone. So thank you, Professors Fudge, Vila, and Professor Rocca for the opportunity of taking part of this seminar. And also thank you for Professor Clina Murphy, with whom I had the first discussions about accessing redress, and it's part of this presentation today. So today, oh, sorry.
Yeah, just click.
Yeah, oops, okay. Yeah, good. So today I'm presenting part of my PhD research project, which is focused on the ways in which laws shape the working lives of au pairs in France and Ireland, though today I'm only focusing on France. And the focus of this presentation is to investigate the protection against labor exploitation in a broad sense of and for au pairs in the country. So before starting, it's important to think that au pairs are young, usually women who move to a different country to learn a language while providing childcare and some housework. The host family or employers in its turn provides food, accommodation, and pays the so-called pocket money, so remuneration. So the methodology of my study that I employ in my thesis and which I used for this presentation as well is doctrinal and desk research with semi-structured interviews that I conducted with au pairs themselves and also relevant associations and trade unions in France. And also I complemented this field work observation with social media and also attendance at a hearing before a French Court of Appeal. So to proceed, as I said, France is one of my case studies, and it's interesting to note that in France, au pairs are not considered to be employees. So France was a source of inspiration, and it was the first country to ratify the European Agreement on Au Pair Placement of the Council of Europe in 1969. So the agreement is from 1969. And this agreement is very interesting because at the time, it established that au pairs belong to neither the student category nor the worker category, but a special one which has features of them both. So it was very much the basis to construct au pairs as a special category, which is not part of the work category. So more recently, we had in France the transposition of the EU directive on researchers and students that includes au pairs as an optional category. And in this directive, the directive actually leaves the floor open to member states to decide whether au pairs shall be considered to be in an employment relationship or not. In the case of France, they are not, as I said. And with the transposition of the directive, France has created a specific visa scheme for non-EU au pairs since 2019. And in this specific visa scheme, au pairs can stay up to 2 years in the country. They must be between 18 and 30 years of age. They have no obligation to study, and they must take childcare so they must care for children above the age of 3. Okay, so au pairs, since they are not employees in the country, they are excluded from the scope of the national collective agreement. And in fact, there is a particular mention to their exclusion, which was not present in the prior version, so in the one of 1999. So it was a recent change. Together with the transposition and the introduction of the visa scheme, the country, so the Ministry of Interior in France, has adopted a model agreement which was already in place, so we have a new version now. And this model agreement is a 4-page contract, so here we can see the first 2 of them. And it's a very interesting instrument because it brings together 2 different legal natures. So on one side, we have a regulated administrative formulary that one have to present before public authorities, so immigration authorities, in order to validate the visa or request the residence permit, but also social security authorities in order to declare those au pairs. At the same time, since it's signed by 2 individuals, so host families and au pairs, it is a contract of private law. One can assume that. And here we can have a look. Sorry, it's short, but it's small. But just to have a look on those, on the first 2 pages of those contracts, we can see that there is information of contracting parties, accommodation, organization of au pair tasks, which shall be no longer than 25 hours per week. Pocket money, which according to the French minister, it's also it's minimum 320 euros per month. Duration and termination, so it brings a minimum period of notice of at least 1 week, and also the possibility of immediate termination in the case of gross faults, although there is no definition of what are those gross faults, and also a part about parties' obligations. Okay, so going on, moving to the former 2 pages of the model agreement, we can see that there is information about guidance on completing the form sections, and also in red, we can see information of associations that might offer help for victims. We can see a helpline of the Ministry of Justice in France to all kinds of infractions that aims to identify the needs of the caller and propose an association service to reach out in case of labor exploitation. So it's not exclusive for au pairs, it's for people in general who are submitted to exploitation. And also a reminder of the applicable articles of the Criminal Code in case of exploitations. So here's some considerations about this. As one can see, the model agreement is very much focused on some forms of extreme labor exploitation if we consider this continuum of labor exploitation. About the helpline victims that I mentioned, I had one participant. She was not subjected to those extreme forms of labor exploitation, but her contract came to an end prior to the period which she expected, and she was immediately expelled, and she had committed no gross faults. So she mentioned to me in our interview that she tried to reach this helpline in 2024 without success. And when she told me that, I was kind of surprised. So I tried myself twice without success either. Also, there is this website, so this link which lists associations that could offer some help to victims of labor exploitation, as I mentioned, but talking to an association that was involved in some sense in this process, they told me that the information is sort of incomplete because in the lawmaking procedure, the idea was very much to focus on prevention of labor exploitation. And if you only have a list and the provisions of the criminal code, it's not as you are really trying to prevent something. Also, as I said, there is this reminder of the provisions of the criminal code that can apply in case of labor exploitation. In regards to exploitation, there's no particular conceptualization by the French Criminal Code, though there is a list of infractions such as forced labor, servitude, and others that amount to exploitation. So now taking a look in this other forms of labor exploitation. So I was asking myself about routine forms of labor exploitation that usually would be tackled by employment or civil law. We can see that law creates structures of labor exploitation, and in some sense, law allows some practice in this continuum of labor exploitation. So, for instance, in the case of au pairs, in this case of this legal framework, we can see this multiple dependence on host families for material needs, so accommodation, food, but also administrative purpose. So, for instance, in order to validate the visa and to obtain the residence permit, it's necessary to present the model agreement, and the model agreement must be signed by host families. Yeah. Also, this idea of help and tasks against the concept of work. So you are not working, you are helping. It just creates difficulties in order to set the boundaries between what is work, what is not work, and also just to define working time. Also about the minimum period of notice, as I said, in the model agreement, there is this provision, but the provision it's very strange. And some participants of my study, they mentioned to me that they didn't know if it was a right, if it was a suggestion, if it was a recommendation. So these questions, they just made me feel that it was very unclear what the provision wanted and actually how one could enforce this provision. Okay. In addition to that, there is no provision for paid annual leave or compensation remuneration for extra hours. And here I claim that omissions, they work as a mechanism of regulation as well, because if there is no provision in this model agreement or in the legislation, it's just left to host families or the industry, so agencies, websites as well, to create standards about the subject. And in addition to that, the poor payment. So for 100 hours of work per month, they shall receive at least 320 euros. Okay. In practice, what I noticed is long working hours, demands for flexibility and constant availability, very much based on this idea of help, of you are a member of the family, or at least you should be treated as such. Also, a widespread non-compliance with this minimum period of notice provision. As I said, au pairs themselves, they told me it could be a right, it could be a suggestion, a recommendation. They didn't know. And also, since there is no particular definition of what amounts to a gross fault, families are very discretionary to say, this is a gross fault, you shall leave now. So it's complicated. In addition to that, also uncertainty on one's rights. So the provisions that are not present on this model agreement, which is very much the basis and the most close applicable instrument that au pairs have access, put them in this situation of not knowing which rights they should have access to. To investigate this violation of rights, it's interesting and one shall understand that a particular situation is a violation of right, and to some extent that this violation of right is a legal matter. So in this frame, I'm using legal consciousness studies in my thesis in order to review and unpack the understandings of au pairs about the violations of rights they are subjected to. So some of them, I used the parentheses using the expression of Barner, Costello, and Fraser-Butlin. They mentioned that this a legal problem, so using parentheses means that participants, they do not recognize a problem rooted in law as such. And here, when I used this, I was investigating how participants identified law to be remote, law to be inert. So when they had a violation of rights, so when they were requested to work long hours, they would not recognize this as a problem rooted in law, because law was distant. They would recognize this as, for instance, an inability of standing for themselves. So it's very much based on the individual. In addition to that, we had another reaction. So participants who identified a particular situation as a legal problem. So these, when they did so, they invoked this proximity to and from the law, and they mobilized law as a means to recognize this violation, or maybe as an end to just argue with the family or to raise a complaint with the family, not in a formal setting, okay? So yeah, we can see that for some of them, violations of rights won't amount to a legal problem per se, but for others will. As I said here, I'm focused on forms of more routine exploitation. So for instance, I didn't have cases in which participants had their passports confiscated or they received no remuneration during a long period, or they were deprived of liberty, okay? Here, I'm talking about more routine forms. So for instance, low payment or long hours which were not paid or not compensated with time off in lieu, for instance. And also a case that was very much common was the lack of minimum period of notice. So, for instance, when in the rare occasions when my participants or acquaintance of my participants sought for help or reached the authorities in case of violation of rights, they mentioned association in one case when an au pair was expelled. Here I included, even though it's not like a public authority, but I think it's interesting just to include because I realized that in order to access redress mechanisms, the help of an association is very much structural in loads of cases in a different context. Also, I had a participant which wrote a letter to the French Ministry of Interior saying the conditions that she was subjected to, and her hope was that this person, or at least someone out there, would read and potentially, I don't know, just raise awareness about what's happening. Also, I had a participant who reached the Conseil de Prud'homme, which is a statutory body with an adjudication function to rule on work-related disputes. And it's very interesting to see this case. This case is the case of Olga, who was not paid for her last weeks of work. So the host family should have paid her 200 euros for those weeks. So she talked to some local acquaintance, and this is very specific of her case because she had contacts which had experience with forms of violations of employment rights in France. So they knew what was the Conseil de Prud'homme and how she could reach this. And it's interesting to see how she summarizes this moment as the moment in which she started to fight for her rights. In spite of that, she continued our interview and she said to me, I didn't want to take that complaint any further, even though I knew I could, you know. I said, forget it, let it go. So I was very much curious about what was her reason or why other au pairs did not seek any redress mechanism, or I don't know, the idea of seeking for help was very much exceptional. So this led me to investigate some reactions and some barriers to individual action, and not only to individual action, but to think about accessing redress mechanisms. And among those barriers and obstacles, one can see the intersection of gender, origin, age, class, and the visibility of care work in private homes. So these social categories and the visibility of care, they operate in a very singular way to justify the legal category, the special category of au pairs, and also this unequal legal treatment if we compare to domestic workers in the country. But they also operate as deterrents to considering accessing justice and proceeding with it. So for instance, when I was talking with associations, they were telling me that women are less likely to pursue a claim, and especially women who work in private homes because it's so difficult to prove and establish a fact that happened in a place in which you have no witnesses and besides your host family / employer. In addition to that, poor language levels, lack of knowledge of the legal system and one's rights, and unfamiliarity with enforcement bodies. You can have an idea if you are a migrant based on your home country, but maybe it's different, who knows. Also, the fear motivated by one's immigration status. To illustrate, for instance, if you worked more hours than your residence permit allows, you can raise a complaint based on that, but I would fear that immigration authorities knew that, and maybe this would amount to problems in order to renew this visa or to obtain a new one. I don't know. A broad fear motivated by that. Also, prior interactions with state authorities. So here I brought a case which was experienced by a friend of one of my participants, and she mentions that this au pair was demanding her remuneration, so her payment, and the host family said they wouldn't pay. They expelled her, they had a conflict, they were on the streets, the police arrived, the family was French, they could speak French very well. The girl could not speak, so she just said, what you can do in this case, right? And it's interesting, like what she mentions, like no one is going to help you. It's you for yourself. Like there is no one to help you. Okay. In addition to that, also the routine nature of most violations of rights. And here it connects to what I said about recognizing this as a legal problem or not. So in some cases, au pairs themselves, they did not recognize as such. So these would not motivate them to, I don't know, just seek for help or seek information about redress mechanisms. And also other relational aspects and cultural norms, okay? Nobody wants to be seen as a troublemaker or a greedy person, right? Just to finish, because I'm running out of my time. So in spite of the lack of complaints raised by participants I interviewed, there are some cases involving au pairs that I could find. So before I propose us to have a look on those decisions and more than that, understand this broader picture of au pairs' access to redress mechanisms and the type of grievance that have been brought before adjudication services. So look into decisions from cases from 2007 to 2025. We can see that most of them sought for the reclassification of the arrangement. So if they sought for the reclassification of the arrangement, it's clear that the au pair arrangement and the model agreement in itself is not sufficient to provide legal protection. So the Conseil de Prud'homme claimed the decline of jurisdiction in several cases, and here I just brought the most recent one, in which it says that since there's no employment contract, even though they were asking to have the contract of employment recognized, the Conseil de Prud'homme was not competent to do so. It's sure that they can appeal, but there are several costs involved, including time and emotion, and time is especially relevant if you are a temporary migrant in this country. Okay. Also, in this particular case, there was this reasoning grounded on the European Agreement on Au Pair Placement, besides the French immigration legislation, right? But in the cases in which there was a decision on the reclassification of contracts, I could see that this decision is rather exceptional, and I grouped my decisions in two groups. So the first group included routine forms of labor exploitation, in addition to the failure to meet certain strict requirements. So, for instance, the violations of rights, they were secondary. Here, the failure to meeting those strict criteria is central to the reclassification. So, for instance, if an au pair was below, it's a case. So the au pair was below the age of 18 or above 30 years old. She was French. Another au pair stayed more than 2 years with the host family, and a case in which the care recipient was not a child but domestic animals. So in those cases, the failure to meet these requirements was structural. to the reclassification, but not the violations per se. In the other group, it was the extreme form of labor exploitation. But here, it's very much an extreme form, right? So for instance, au pairs worked more than 10 hours per day and were not paid accordingly. So I'm finishing my presentation, and I finished this presentation with a provocation that I think I'll be working on in the next few weeks. So what options remain to au pairs facing routine forms of labor exploitation when these strict requirements are met, which are the case of most of my participants. So thank you very much.
Thank you, Katarina. You can stop the sharing screen. Yeah, and turn off the mic. It's okay. You can stay there. Okay. So thanks to all the speakers. I will open the floor for questions, comments, suggestions, curiosities, and so on. Of course, I have a few of my own, but first I will also let the others in the room or indeed online at home to ask them. If you want, you can put them in the chat, of course, or if you prefer, just raise your hand in the Zoom and we will see you, and you can start your microphone and camera, of course. So if anybody in the room has a question to start, of course, the speakers can also ask questions to other speakers. So please feel free, and otherwise I also can start. Melanie, please. I will bring you a microphone, maybe, if it works. Or you can come to a microphone. Okay. Yeah, please.
So thank you very much, Marco, and thank you very much for your presentations, dear colleagues. I have a question for Judy first. Could you come back to the definition of exploitation and more precisely do the notion, the concept of vulnerability play a role in the documents, the text you mentioned? And for Mireia, also a brief question. Could you say a little bit more about the need to move from the concept of indirect discrimination, which normally can grasp the situations you described, and what is what brings the concept of intersectional discrimination for the protection of women at work, domestic workers. Thank you.
Thank you. That's a quick, very important question, which I should have started with. The Human Trafficking Protocol was adopted in 2000 by the United Nations within 2 years, which is a record time. And it was based upon a series of treaties that started in 1904 and were adopted by the League of Nations. And they were designed to prevent exploitation of women, mostly white women in Europe, who are moving throughout Europe or to the colonies. And what it did was it made it a crime. So the early ones, 1904, 1909, 1910, 1932 changed it. It was white women who were being transported for the purposes of prostitution. So prostitution and race were considered, and the idea was to protect the purity of women. In 32, race was taken out, so it could be women of any race. And in 49, men were included and boys, but it made prostitution the only example of exploitation. And that was adopted mostly by European countries and a couple of Latin American countries, Argentina, for example. In the protocol, the debates around human trafficking, which was the Human Trafficking Protocol, is a protocol to a United Nations treaty on transnational criminal law. And there's 3 protocols, one on trafficking of weapons, one on trafficking of people, and the other on trafficking of drugs. And parties couldn't agree. So there was one group of feminists who thought all prostitution should be exploitation. And then there was another group of feminists who said, no, we should be looking at exploitation, which should involve coercion or fraud. And to come up with the consensus, the United Nations drafters decided on strategic ambiguity, which is often used in legal drafting to get a consensus at the international or EU level. So the definition of human trafficking has 3 elements: means, movement, and purpose. And exploitation is the key. And exploitation is not defined. It's a list. So it includes prostitution, sexual exploitation, forced labor, slavery at a minimum. So it's an open-ended definition. So international norms of forced labor. So forced labor is compelled work through menace of penalty. So it's involuntary and menace of penalty. Slavery, the treaty, 1926, control as like property, so mostly modeled on chattel slavery. The 56 amendment to the treaty includes servitude. So this was the debate. It's a very open textured definition. So the question is, can you have exploitation without coercion? That's the key. So that big debate is, how do you define exploitation? Is prostitution per se exploitation? Does forced labor always require coercion? So the Fundamental Human Rights Agency of the EU said that no, it can't just be coercion. We'll have a 2-tier notion of labor exploitation. One will be forced labor, which entails fraud or coercion. And the second will be based on the sanctions directive, which means providing pay and working conditions much beyond what you provide to nationals. So there are vulnerabilities that are recognized in the human trafficking the human trafficking protocol upon which the EU directive is based. It specifies women and children, because mobile women, we are very dangerous. Yes, because we're just really dangerous, right? I mean, we could be exploited at any point in time. So that's one thing. And then, of course, for the other, it's about migrants, because they're not having the conditions. So there is a vulnerability based in, but it's one of the concerns I have about vulnerability. If vulnerable people need protection, then maybe we need to constrain them. They shouldn't be working at night. They shouldn't be crossing borders. They shouldn't be working with men. So there's a upside, downside to these kinds of things. So that was a very helpful question. Thank you very much.
Mireia.
Thank you for the question. I was kind of expecting some that type of question. And
The camera, they're seeing us. I will check. It's okay. They're hearing you, so. Yeah. They can see you. You can answer.
okay. The difference between indirect discrimination and intersectional discrimination is that indirect discrimination occurs when a neutral rule, criterion, or practice places a particular protected group at disadvantage compared with others. The key idea is that the measure appears neutral, but its effects are disproportionately harmful. And the comparison in existing today's case law prior to the Pay Transparency Directive, which hasn't come under the analysis of the European Court of Justice or the European Human Rights Court, is based on a single axis. Intersectional discrimination, by contrast, refers to situations where a person is disadvantaged because of the combinations of two or more protected characteristics, as in the case being a woman, a migrant, and racialized. And the harm does not come from each characteristic separately, but from their interaction. It is not simply double discrimination, it is a specific form of disadvantage that cannot be understood through one axis at the time. Historically, and at present, we're expecting a shift in this case law. The European Court of Justice relied on real comparators. That's why I pointed, or I highlighted the issue that I think the expansion to hypothetical comparators is particularly useful, but nor the European Court of Justice or the European Human Rights Court has, for the moment, integrated in their approach intersectional discrimination. I mean, they may be subtle conclusions drawn on multiple factors, but for the moment they are rejecting that approach. That's why the authors are asking that the Danfoss doctrine to be revisited, and I hope it is, after such excellent researchers continues stressing on this approach.
All right. Any other questions? Otherwise, I will also ask one of myself. So to give the others the time to come up with other questions. So my question comes from something that was mentioned by Mireia, so particularly talking about sectoral approaches. Okay, and Judy also talked about the scalar governance. At which scale do we govern this phenomena? And my question would be, how do you feel about sectoral approaches in these fields? And of course, Katarina's research is sectoral by nature, but it's something that we are confronted with quite often in terms of, in particular, domestic care work and its specificities. But yesterday we were talking about agriculture, and it's easy to every time to be tempted that these situations are different. Okay, to say this is all different. So is this something productive in our reflection on this phenomena, on the continuum between forced labor and everyday exploitation, to think in terms of sectors and sectoral approaches for solutions? Or again, do we lose something when we go into sectors and we invite basically playing with the law and playing around on what is inside this sector and or not? So it's a question for everybody, but you can decide who wants to start tackling it. Of course, Mireia mentioned it directly in her presentation, so I think I will give you the floor first.
Oh, very briefly. Absolutely. This is where it's the basis of my presentation, is the fact that domestic work requires a sectoral approach. The characteristic that it is based inside a private home, like in the presentation on au pairs by Catherine, makes it completely different. Especially in my case, I have focused it on the enforcement approach, has to be completely different. Maybe declarations, or let's say court approach, can be similar to different sectors. And here, the fact that we have a high percentage of migrants and women also requires a completely different approach. And is and as far as undeclared work is concerned, number one sector in undeclared work is domestic sector. So I don't think you can work in undeclared work without having a specific view on domestic work.
Yeah, I think you need general norms and standards. So, for example, I think it's wrong that in agriculture you have normative standards that exclude agricultural workers from overtime, paid overtime, and statutory holidays because consumers need cheap food. I think we need to deal with that in a different way. I don't see why migrant agricultural workers should subsidize the food costs of people in richer countries. Seems wrong to me. That's my normative view. So I'd want general standards, but you have to have a sectoral approach because how you enforce depends on the structure of your market. So, for example, if I'm concerned about migrants being charged illegal recruitment fees, the easy way to deal with it is say, well, I'll target the recruitment agencies. Well, that's whack-a-mole. They're undercapitalized. They come, they go, they can phoenix, directors can set it up again. So you can't deal with the problem by simply going after recruitment agencies. You have to make the client firms who are capitalized, who aren't mobile, responsible for the recruitment agencies. That will deal with one of the problems. If I'm thinking about dealing with problems in the garment sector, going after suppliers is not going to be my solution because they are in competition with each other and the pressures are driven by the lead firms. So I have to think of the structure of the market. Trucking. Small trucking agencies, that's not the problem. Amazon's the problem, right? So really, you have to, if you're at all concerned about effective enforcement, you have to look at who has the economic levers that drive the exploitation and who can't move easily. That's the solution. Now, of course, the reason why we go after the low-hanging fruit is we don't want to see it as a structural problem. We want to see it as bad operators who taint our market rather than thinking of the market as having an impetus to exploit workers.
Follow up to that, Judy. Does it entails going after families using, domestic work?
I think the French system of the ticket is a really good system. I think it's really too bad look, there is a real problem around individualizing the issue. If you don't provide social supports to raise children and deal with elderly, families will do the best they can. Moralizing the problem is not a solution. That's when we bring in criminal law. I'd rather actually not moralize the problem and say, look, we have a social issue of how do we support the needy and dependent in our society and who should be paying for it. Well, we all benefit from the next generation of children and we all benefit from elderly who pay taxes. So we should support them.
Katarina.
I share the view with my colleagues, and I think for me it's quite obvious since I'm dealing with a very specific feature inside a sector. But I also believe that if we are talking about like domestic work, it's just impossible to not think about the specificities of domestic work if you aim to enforce the legislation, but also if you aim to construct voices and make it possible for people to stand for them rights, and also to just, I don't know, join a union or join an association, or I don't know, any other type of collective organization. Because if you are dealing with isolated people, you have to have a very specific approach to enable them to do that. But having said that, I also believe that we should frame the problem in a structural way. So if we are talking about the care crisis, we also must take in consideration that it's not only specifics to care workers, but also families who must afford them, and also in this capitalist setting. And also, besides that, having a sectoral approach does not make it impossible to learn with others. So for instance, if a particular sector, I don't know, agriculture, had a nice initiative to enforce rights or to labor inspection, I don't know, it does not hinder us from learning with others and try to adapt to this sector. So I think, yes, you should have a sectoral approach, but you should also look to other sectors to see what they are doing in order to learn from others. So that's my view.
Thank you. Now I will read the question from Natalie Sedaka. Hi, Natalie. Natalie is one of the speakers for a summer school happening this July here in Strasbourg. So Natalie asked to Mireia how the national plan to tackle illegal work in France interacts with migration status issues. For instance, if labor inspectorates find workers with irregular status, is this kept separate from migration enforcement or not?
Structurally, there are different competences. So when I studied the different government instances, there are many, and a local, municipality, regional, state level. I think migration, there were specific bodies for migration, which were different from labor enforcement. But it is true that labor inspectors, they have a specific section for what they call, because in France, you call it illegal work, which is a broader concept than undeclared work. It involves also criminal action, as while the European concept of undeclared work does not include criminal activities. Labor inspectors, they do report when they find illegal work, but they also report it to the police, to the immigration authorities. So they act in coordination. But of course, labor inspectors, they do intervene.
I see another question. All right, from Emmy Wedderburn. Hi, Emmy. Thank you for your presentations. Judy referred to the conceptualization of exploitation under the Sanctions Directive, which we see being co-opted in subsequent EU instruments that include protective provision, such as the 2024 recast Single Permit Directive. Now, the question for you, Judy, do you think that this is the direction that EU will go to understand the labor exploitation in the absence of a definition? And is this problematic when it comes to anti-trafficking effort? There is also a question for Katarina. Can these different approach help with better adjudicating routine forms of exploitation? Judy.
Thank you, Amy. That's a great question, and I admire your work around this topic. I think it's likely the way that the European Union will go after the report of the EU Fundamental Rights Agency. It's already embedded in the sanctions directive. The only concern I have with it is that it's going to be a criminal law instrument. And having dealt with criminal law issues around rape and criminal law issues around migrant sex workers, I mean, I think it's really difficult to use the criminal law. Police are very expensive. There tends to be a lot of corruption with them. And the burden of proof is really high. So for me, the question is whether it should be a criminal law mechanism or whether we should have other forms of mechanisms. I think that the definition is important, but the mechanisms for me are much more important. So I'd like to see firewalls between labor inspection and immigration reporting, because as soon as we know that a labor inspector is going to rat you out to an immigration person, you're not going to complain. So for me, the definition, I think the sanctions directive definition is good. I just think that the criminal law is not the appropriate mechanism for remedying these problems because of problems of burden of proof and operatives. So I would think of other forms of sanctions, fining, refusing them to do work. Some of the sanctions that Mireille introduced in her undeclared work in the French form. But thank you for the question.
Katarina.
So thank you very much for the question. So I think in parts it could assist in order to bring claims on routine forms of exploitation before criminal courts. So it could be helpful. But if we are dealing with routine labor exploitation, as I said, there are multiple obstacles and barriers. And I don't believe that with this definition, those barriers would be pushed down. So I believe that they would remain. So basically, it could be helpful, but together with Professor Fudge, I don't know if criminal law is per se the best answer. And I think that in this situation, it would be much easier to refer to criminal courts. But au pairs, would they be more protected by that? I don't believe so. And I think that here I brought some obstacles in regards to accessing redress mechanisms in situations of routine labor exploitation, as I said, and they were basically dealing with case of reclassification of contracts of employment. And I think when we are talking about criminal law, there are other obstacles. So, for instance, in the case of au pairs, there this dimension of sometimes this person does not want to be called an employee because it deals with social status, it deals with recognizing that employment has maybe this nature of a not good condition. This was what I obtained from my interview. So when they referred as that they felt as an employee, it was basically to say that there were bad conditions, poor conditions, whatever. And I believe that there is already this difficulty to recognize oneself as an employee. I believe that if you are to recognize yourself as a victim, because if you are dealing with criminal law, you are a victim, I believe that there would be more obstacles and maybe it would be easier to access, but maybe it would have more obstacles to access. So I don't believe that the results would be great, to be honest.
Mireia, please.
Something very brief. Of course, criminal law does not solve social problems, but I think it acts as a very effective deterrent. So often companies or even individuals, they ask corporate lawyers or attorneys, how much will this cost me? How much will not complying with this law cost me? And it's only an issue of money. And they're ready, because normally it's not very costly. But when a CEO asks you, will this bring me to jail? Then that's a very different issue. And they adapt their behavior in the market. So for me, yesterday I was actually praising the fact that you have criminal approach in your labor code, and I think is very useful. Not so much. I do not believe in the criminal procedure, but I believe that stops prevents irregular behavior.
Okay, thank you very much for your answers. Any further question from the room, from online? And if there aren't, I will move to my role in saying something to close this seminar, which is of course particularly hard considering how interesting and specific some of the presentations were. So a few things that I picked up here and there. We titled the seminar "The Border of Exploitation," so wanting really to reflect on borders, and of course borders. When we talk about migration, it's easy to imagine only the national borders or European borders and so on. But here the reference was very much also to legal borders, and we have seen them emerge in this presentation. Now, legal borders, just as national borders indeed have a role in organizing the labor force, in filtering the labor force, and through migration governance, they are also a tool to organize the labor market, ultimately. And this very much covers even extreme situations of trafficking, exploitation, and so on, because of course they create their own terribly exploited and extremely vulnerable workforce, which will take some segments of the labor market. And then in the continuum, from forced labor, exploitation, to undeclared work, to routine exploitation, even of formalized situations, we see this structuring of labor markets, and we see the creation of these vulnerable workforce, specifically in certain sectors, where the pressure on even in our case for today families, which feel the squeeze of their purchasing power, and on the other hand of their time, potentially. So even better off families are squeezed for their time. They end up being time poor, and as such to have recourse to domestic and care work and so on. So this double squeeze then translates into this need for this workforce. So in this continuum, we see the play between deservingness of protection for victims of exploitation and trafficking and so on, and that we evolve into the deservingness by needs. So the labor market needs these migrants, so they deserve to be in, not them themselves. We would, as unfortunately the society, happily do away with their person as a human being, but we need the labor. So in this continuum between deserving victims and deserving providers of workforce, we see the switch between criminal law and sanctions, and then little by little into labor law and money in the end as sanction, with all the limitations of both systems of enforcement. And I think the reflection on the role of criminal law in the end of putting an ultimate, difficult to monetize sanction over the head of employers, intermediaries, and so on, has potentially a role to play, even to underpin labor law violations, ultimately. And then we continue into the border of employment itself. And we have seen it play in different ways. On the one hand is undeclared the question of undeclared work, so the border between work which is legally recognized as such or excluded from legal recognition, but also then into OPEs, who are sometimes, such as in France, organized as a special category, which is a very nice way often to exclude somebody from rights. And we can see also play into, it was not the object of the presentation, but made me think of bogus self-employment, which is a way in which a large part of care work and especially live-in care for old age work is organized in continental Europe, with posting also playing into the mix. And bogus self-employment is another example of this border of employment playing the segmentation and filtering of the workforce. So all of these borders bring us to the moment of crossing this border. And in many cases, crossing this border is through either labor inspection or police activity in the case of trafficking, or action by the workers themselves. And it's at that moment that the border of employment, the border between recognition, non-recognition, and so on is crossed. And it's at that moment that we need the reflection on the effectiveness of our tools. And again, I'm sure I'm saying something that is very much common sense among the listeners, the person present here, but the reflection on the firewall between labor inspection and migration enforcement is necessary. And in many cases, I see when I discuss with non-specialists, I see a lot of complacency on, they see the US and what's happening there, and we feel very different. Of course, it must be different here. But actually, when you talk about the practice, I have discussed with people, for instance, in Belgium, that told me, no, if the labor inspection arrives, then it will be communicated if there is illegal work in the sense of migration status, which is not declared. So even as researchers focusing on Europe, we need to push forward this point. And I've seen it play myself, the illegalization of migrant workers in Europe through the interplay between migration and posting of workers, with the intra-EU posting of third country nationals, where third country nationals sent to another member state and their presence there, their legal presence there, is tied to their being posted, which means a completely business arrangement entails their legal status, a business arrangement that can be stopped as a business contract. So very easily and very quickly, and they will find themselves in another member state without a legal document for their presence. So the illegalization moment, so the crossing of this border, even for those who were on the good side of the legal border in the member state, is really something that reinforces this necessity of thinking of this firewall and of the protections for victims, which here would not be defined as victims in the sense of trafficking or forced labor. They were just posted workers, but they are to some extent victims to this illegalization of their presence. So we need a broader sense of who are the victims in this, and to allow for some. And again, this is completely wishful thinking, because the idea of accepting, protection for migrants that we did not choose, it's unfortunately difficult to imagine in the present political climate. But in terms of enforcement of social rights, so beyond the question of justice, but even just as a question of effectiveness of a system of enforcing labor rights all across the spectrum of violations, this is essentially a necessity. Because otherwise it is unthinkable that any system of enforcement will work under such a structurally unfavorable conditions. And this brings me to the last point, which I think emerged here and there quite interestingly, and far from me of being a critic of trade unions, quite the opposite. But I think we have heard a lot of associations of the role of non-trade union actors, sometimes because of the extreme exploitation situations, which make it more, let's say, closer to human rights actors and so on. Sometimes because of the types of organization, for instance, for domestic works, women, migrant workers, and also au pairs and the nature of social networks and so on, it makes emerge this role of non-trade union actors in the context of social rights, in the context of the enforcement, information, and so on of social rights, and also as a way to deal with the spatiality of exploitation, so the secludedness in the case of domestic and care work of private houses, in which labor inspection might have a hard time accessing. So the role of these different actors is indeed something we need to consider. As myself as a labor lawyer, I'm always very suspect of non-trade union actors, which can have problems of autonomy, independence, diluting the role of social and labor rights as opposed to human rights and so on. So without forgetting all these questions, but it clearly emerges in this situation as somewhat of a way to make emerge these violations and these situations again under extremely tough structural conditions. And this leads me, and the last point is vulnerability, of course. And Judy pointed out how dangerous it is as a concept, a potentially slippery slope towards infantilization, paternalism, and so on. So instead of using it as a parsing tool for the law, if you want, one way to use vulnerability is really to direct enforcement activities and inspections and so on. So more the sort of work we do now with data analysis and so on, which now drives a lot of inspections, which is data driven on knowing on sectors and companies which have a statistical tendency of being violations. In a way, we can maybe come up with scoreboards for vulnerability as well to drive this data-driven enforcement. So not as a tool to apply, rights or protections or differentiated treatment in the law, but to have a guidance for inspections. And some of the situations we mentioned could very well, and again, I'm saying something completely common sense in the sense that, yes, they are in a very difficult position, but this should raise red flags for inspections, be it, again, work of migrants in private houses, posting of their country nationals, situations which can give rise to trafficking, and so on. So maybe vulnerability is a good data parsing tool and not as a rights parsing tool. And that was my last point. So thank you very much to all the speakers. Thank you very much for everybody asking questions. To those who were with us during the seminar online, thank you for those who have already said their goodbyes. Thank you for those who were here in person with us in sunny Strasbourg this morning. So have a good rest of the day, evening, morning, depending on your time zone, and see you next time in another European Birds of Passage activity. Thank you.